Welcome to our three-part web series. Our mission is educating you on the power of using experts to help you decode Medicare, long-term care, and elder law issues. When you are empowered with accurate and efficient information, you can protect your family well, spend your healthcare dollars well, and remain calm and confident in your daily lives. The group of experts we have for this series include Keith Knabb of Affordable Medicare Solutions, Sabrina Scott of Red Feather Financial, and Shannon Pauley of the Estate and Asset Protection Law Firm. Each expert will highlight one area of information in each 15-minute segment. Previously, we heard from Keith Knabb on making Medicare work for you and Sabrina on planning for long-term care. Today, we will have Shannon talk to us about 3 basic estate planning documents everyone over 18 should have. During her legal career, Shannon has represented the full spectrum of clients from international blue-chip companies to single parents. After 10+ years serving as a vice president for a national law firm, Shannon welcomed the opportunity to return to her estate planning roots. At her current firm, Shannon is able to focus on her passion to help her clients age with dignity, grace, and independence throughout their lives while assisting the client to create their post-life legacy. Shannon, please introduce yourself to our audience.
Thank you very much, Sabrina. Good day, everyone. My name is Shannon Pauley, and it's my pleasure to speak with each of you today. The topic that we're going to be discussing today is the 3 basic estate planning documents everyone over the age of 18 should have. Now, what I want you to notice here, that magic number, it's 18 for estate planning documents. It's not 55, it's not 65, it's not 72. These are documents that everyone, once when they hit the age of majority, also known as the age of 18, that you should have. So you can't have a conversation in this type of environment with an attorney without having a disclosure. So what I'd like to emphasize to everyone that is observing this presentation today is that I'm presenting for educational purposes only. Nothing I state should be construed as legal advice. While there may be several things that I discuss that pique your interest, that might actually be something you want to dive deeper into and learn more about, my comment to you is please seek the advice of an experienced estate planning and/or wealth protection attorney regarding your particular circumstances in regards to those seeds that I'm planting with you today. And if you don't know an attorney or don't currently have a relationship, don't hesitate to reach out to myself or my firm. I'll give our contact information at the conclusion of today's presentation. So let me tell you a little bit about myself. My name is Shannon Pauley. I am the managing attorney at the Estate and Asset Protection Law Firm in Decatur, Georgia. I'm a dual state licensed attorney. I'm licensed in both the state of Michigan as well as Georgia. In addition, I do have a master's of law in tax. I have over 20 years experience as an attorney, and I focused in 3 main areas. The first is estate planning, makes complete sense. That is where I'm happy at. These are my roots. This is my warm fuzzy blanket. But also I've done tax planning, makes complete sense. I have a master's of law in tax. In addition, I have several years experience doing creditor rights. Why do I like to emphasize this here? Because it's showing the different perspectives that you get by coming through myself and my team, because when we are drafting, I'm looking at things both as a drafter to promote that what you want, but also as a creditor trying to figure out, if I was the creditor on the other side, how am I going to handle this? How am I going to try to pierce it? And I try to make it to where it is ironclad. I'm proud to say that during my high school years, I was a nursing home volunteer. I am a proud daughter of and wife of Navy veterans. And I did have the honor my junior year in high school to serve on Capitol Hill in Washington, D.C. as a U.S. House of Representatives page. So here at the Estate and Asset Protection Law Firm, our firm's mission is to ensure that people live and die with the highest quality of life possible. So you may ask the question, how do we do this? Well, we do this by listening, educating, and then preparing solid estate plans designed around your self-directed choices to preserve your independence as well as your assets. So if you remember, I said there's 3 documents that everyone over the age of 18 should have. And let's talk about the first one here, and that is a will. So we always hear you need a will, but let's discuss exactly what is a will. A will, it's a legal document that details your instruction for distribution of property after your death. Think of it as a roadmap stating anything in your individual name at time of death, how it can go from you, then follow the map to get to the ultimate beneficiary that you want to be receiving your property. Now, what are some of the pros of having a will? Well, a big pro of having a will is that you get to leave your property to those persons that you choose. Without a will, the court system could determine who gets your assets, basically under the laws of intestacy, meaning that you died intestate without a will. In addition, by having a will, you get to choose your executor, meaning the person that's going to be handling the distribution of your assets. Without a will, the court would appoint someone to administer over your estate. That could be a person that you know that seeks out the appointment, or it could be a third party that you have no relationship with. Now, within your will, you can also plan for personal matters such as burial, pet care, etc. Your will, you have the opportunity to create testamentary trust. The beauty of a will is one can be prepared quickly. I'm sure we've all seen those movies where someone's on their deathbed and in runs the attorney and has this document, and the person leans over, they sign it, and everyone has this look of relief, and then the person dies. They can be prepared that quickly and have effect that quickly. Wills, they can be amended and you can revoke them. They aren't concrete, they're not set in stone until you die. Now, these are all the great pros, but as with most things, there's both sides of the coin. You got the pros and you got the cons. So what are some of the cons of a will? Well, it only takes effect at death. That's why you can amend it all the way up until your last breath. Now, a lot of people have a misconception that a will is your ticket out of probate. And that's actually not true. Because even if you have a will, you may need to go through probate if you actually have anything in your individual name at the time of your passing. Another con of a will, you lack privacy. As the will becomes public record once it's filed with the probate court. The biggest example I give is if we sit down and if anybody's ever watched TMZ, the moment that a celebrity files for divorce, usually within 15 minutes, it's all over the internet, it's all over the news, you know, TMZ is reporting it, and your first response is, oh my gosh, who did this? Who violated that person's privacy? This isn't right, that's not cool. But here's the thing, they did nothing wrong. It's a public record at that point. As soon as you hand it to the clerk, it's public record. For sake of arguing with the person that comes in right behind you, you can ask to see a copy of your will. Now, people can challenge your will. That's another movie that we quite often see where one person has the will and goes, I have this will. And then another person says, but wait, I have this will. And then there's a competition of the wills, or there may only be one will and somebody challenges it saying undue influence led to that person changing everything in their will. Now, I'm not sure if some of you in the audience today own real property, and those that own real property, I'm just curious, how many of y'all guys own property outside of the state of Georgia? Because if you own property in multiple states, and if you die with those properties in your individual name, you may be requiring the involvement of what's called an ancillary probate proceeding, because you're going to have to file in the other state where that property resides, because Georgia probate courts have no control over the retitling of property outside of its state borders. And last, a will is not going to address any estate or income tax concerns you may have. So the biggest things I want you to see here is a will is a very important document, but it's a first step on your estate planning journey. It's a necessary step in your estate planning journey. And it's one that starts once again at age 18, because you may not think that you have any assets today, but that doesn't mean that you are not going to have some form of a windfall, or that you may not be subject to some form, your state may not be subject to some form of recovery, you know, litigation or etc. It's one of the reasons that if you go into the military, you're in boot camp, guess what? You're always completing a will. And those are examples of my 18-year-olds that complete wills. Now, The second estate planning document that anyone over the age of 18 should have is a financial power of attorney. Now, this one's really important because let me explain exactly what that financial power of attorney is and what they're able to do. So a financial power of attorney is a legal document that allows a person you designate to perform financial actions and make financial decisions on your behalf if you're incapable of doing so. And this would include legal access to your bank accounts, the ability to pay bills, the authority to enter into or terminate contracts on your behalf. Now, at your first glance, you might go, okay, legal access to the bank accounts. I'm joint on the account. Well, guess what? You may be joint on an account, but that's not always the strongest strategy you want to be doing as estate planning. I call that layman estate planning, and there's a lot of risk that happens with that. In addition, the ability to pay bills. Nothing is more frustrating than when someone unfortunately gets to a point that they're incapable, very often due to medical issues, to be able to pay their bills. Now, let's say that we're dealing with an individual who has minors. Well, those kids have to eat. Those kids have to have a place to live. Those kids have to have clothing. Well, without a financial power of attorney being established, naming an agent to have access to not only the bank account, but also be able to pay the bills, you run a risk that your loved ones aren't going to have that access to maintain their quality of life. Also, it's the authority to enter into and terminate contracts on your behalf. Now, this is beneficial to both you as well as the agent. I'm going to use an example of a, let's say that you designate your child as your financial power of attorney, and due to progressive health concerns, you now need to go into a skilled nursing facility, and you yourself are not lucid enough to enter into any type of contractual negotiations. So not only is this document giving your agent the power to enter into that contract to get you into that special or that skilled nursing facility, but also this document's also giving some protection to your loved one. So that as they're signing this document, they're signing it in their agency capacity and not in their individual capacity. So let me put on the hat that I used to wear as a creditor rights attorney. Nothing that I loved more than when I had some contract that someone entered into, and now I have the principal of the contract, which in this case would be the patient that's staying at the skilled nursing facility, which potentially could be you. But now I've got somebody that signed this contract also in their individual capacity. So now I've got another source of income to collect against. So by not having a financial power of attorney, you're actually exposing your loved ones to potential financial risk that could be subsided through appointing them as your agents. Now, the third and final estate planning document that I want to discuss is the healthcare power of attorney. Now, what is the healthcare power of attorney? Because we just talked about a financial. What's the healthcare? So a healthcare power of attorney is a legal document that allows persons you designate access to healthcare records, consultations, and the ability to make healthcare decisions on your behalf if you are incapable of doing so, which could include such things as legal access to your medical records, to discuss your medical treatment plans with your doctors, or to make healthcare decisions on your behalf. What I emphasize here is we are in a very litigious world, and doctors and healthcare professionals are very, very aware of the litigious nature of the world, and they are very concerned about the high risk that it has. One of the reasons, among others, is why we have what's called HIPAA. And under HIPAA, there is legal requirements of non-disclosure. And without a healthcare power of attorney, also known as a medical directive, you are separating your loved ones from active participation in your medical treatment plan due to lack of authority to be able to engage in those conversations. Now, your first reaction might be, but I'm the wife, I'm the husband. Okay, Well, here's my comment I have for you. Let's talk about something that probably you've experienced in the last year. When's the last time you went to your family practitioner, your family doctor? I can guarantee you every time you go, at least once a year, you're signing a new HIPAA statement. And then in that HIPAA statement, you're specifically disclosing who you want to be able to discuss your medical treatment records with, and et cetera. And each time, I know myself personally, I personally have to say my husband's name there so he has access. So just because you're a spouse, you don't immediately have access to these rights. But in addition, have the ability to participate in the healthcare and medical decisions. This is also an opportunity through this document that you can proclaim how you want your end of life to happen. Because, for example, the Georgia Medical Directive, it does have a particular section in it to where if one, two, or all three of certain conditions are met, then it would lead to a specific treatment plan. The normal example that I like to give is a person that's in a vegetative state with virtually a non-existent chance of ever getting out of the vegetative state. Now, we all have our personal views of how we want our end of life to be handled. And through a healthcare power of attorney or medical directive, you're going to declare, in my example, if you're in that permanent vegetative state, what do you want? Do you want all the bells and whistles? Do you want them to keep you alive through every medical means possible? Because there may be that slim but possible chance that you'll have recovery. Or are you the type of person that doesn't want to be hooked up to machines? You actually want to be allowed to die naturally, but you don't want to be in pain. Or are you kind of the combination in between where you don't really want all the bells and whistles of medical involvement in prolonging your life, but you want to be allowed to die naturally with the assistance? For example, we're currently in a COVID-19 environment, and a respirator and being able to breathe is of significant concern to most Americans and people worldwide at this point. And you're going to be able to declare, well, I don't want to be hooked on a machine. I do want to be put on a ventilator to help me breathe. Or it might be that you want to receive nutrition or hydration. But aside from those specifics, you want to be allowed to die naturally and pain-free. Now, I bring this also up to emphasize here's the kindest gift you could ever give to a loved one. Because imagine your loved one sitting there in the emergency room. They are stressed to all ends. And now the doctor comes in and says to your loved one, okay, sorry to tell you, but Shannon is in a permanent vegetative state. There is an extreme slim chance you will ever come out of this. What do you want me to do? Am I pulling the plug, or am I leaving her hooked up to machines? And if you didn't have this directive, imagine what's going through in this person's mind. On one shoulder, they have the, well, Shannon's a fighter. So I feel if there's a chance, I mean, Shannon's going to purse through. She's a fighter. She's going to be that 1%, exception to the medical expectation. Or at the same time, on the other shoulder, this person would be going, but what if she's in severe pain? She's screaming out silently, just wanting relief. And by me prolonging her life with medicine or doctors or machines, I'm just prolonging the pain. So I just emphasize here that by pre-declaring what you want to happen, you are allowing your loved ones relief from having to make that decision, and instead of living up to your legacy, the honor, they get to honor you in your final life stage as to how you want to live your final days. And as I keep saying, that healthcare power of attorney or medical directives is the kindest gift you can give a loved one. So for more information about these documents or any other estate planning documents that you would like to discuss, please don't hesitate to reach out to our website at www.elderlawgeorgia.com. You can feel free to call my office if you'd like to discuss your personal situations at 404-370-0696. And last, don't hesitate to reach out to us by email at info@elderlawgeorgia.com. Back to you, Sabrina.
Thank you, Shannon. That was very interesting and certainly timely information. There is a sense of relief that comes with an experienced professional in your corner who can guide you through the estate planning process by providing a well-drafted estate plan. You can see this presentation on Keith's YouTube channel, or we can send you these slides by emailing info@elderlawgeorgia.com. Also, Shannon has a wealth of educational material for free download at her website, www.elderlawgeorgia.com. Thanks for viewing today.